Hello everyone, I am Advocate Sanchit from NRI Legal Services. Today we are going to be discussing about the Foreign Exchange and Management Act with an emphasis on repatriation of funds from India to abroad as well as its tax implications. We get a lot of questions about the topic that we are going to be discussing today. Therefore, I will try to simplify these complex procedures for you. The Foreign Exchange and Management Act, which is commonly referred to as FEMA, is an Indian law that was enacted in 1999. The purpose of FEMA is to consolidate and amend the law relating to foreign exchange with the objective of facilitating external trade and payments, promoting the orderly development and maintenance of the foreign exchange market in India, and regulating the capital account transactions. Under FEMA, the Reserve Bank of India, or the RBI, has the power to regulate foreign exchange transactions in India. The RBI is responsible for the administration of FEMA and has the authority to make rules, regulations, and even notifications for the implementation of this act. FEMA has significantly eased foreign exchange transactions and has made it easier for individuals and businesses to conduct international trade. The Act has also helped in maintaining the stability of the foreign exchange market in India. However, it is important to note that any violation of the guidelines issued by FEMA can result in penalties and legal action. So it is crucial for individuals and businesses to comply with the regulations that have been set forth by the Act. FEMA also governs foreign exchange transactions, including repatriation of funds. So what do we mean by that? Repatriation of funds refers to the process of transferring money earned in a foreign country back to the individual's home country and vice versa. In India, repatriation of funds is allowed under FEMA for various purposes, including investment in foreign countries, payment of fees for studying abroad, and repayment of loans that have been taken from foreign institutions. To repatriate funds under FEMA, an NRI must comply with the regulations that have been set forth by the Reserve Bank of India. So the individual must provide supporting documents to show that the funds that are being repatriated were earned through legal means and all the taxes have been paid. Additionally, the amount that is being repatriated must not exceed the limit set by the RBI, which varies depending upon the purpose of repatriation. It is important to note that failure to comply with FEMA regulations can result in penalties and even legal consequences. Therefore, it is advisable to seek professional guidance while repatriating funds under FEMA. The Reserve Bank of India has issued regulations for non-resident Indians or NRIs under the Foreign Exchange Management Act. These regulations aim to govern the transactions between NRIs and the residents of India. So what are these regulations? As per these regulations, an NRI can maintain different types of accounts in India. What are these accounts? Number one is the non-resident external NRE, then followed by the NRO, which is the non-resident ordinary, and the foreign currency non-resident or FCNR accounts. NRE accounts are used for holding and managing income earned outside India, whereas NRO accounts are used for holding and managing income earned in India. FCNR accounts, on the other hand, are used for holding foreign currency deposits. NRIs can also invest in Indian securities and properties under FEMA regulations. However, they need to follow certain guidelines and obtain necessary approvals from the RBI before making any such investments. FEMA also deals in foreign exchange transactions and activities in the country. There are several tax implications under FEMA that individuals, businesses, and even organizations need to be aware of. One of the key tax implications under FEMA is that any income earned received in foreign currency must be reported to the Reserve Bank of India and the Income Tax Department. This includes income from foreign investments, assets, and services provided to foreign clients. Another tax implication under FEMA is that there are restrictions on the amount of foreign currency that can be carried in and out of the country. Individuals can carry up to US 3,000 or its equivalent in other currencies, whereas businesses and organizations need to comply with the guidelines that have been set by the RBI. In addition, There are certain tax implications under FEMA for individuals and businesses that engage in foreign exchange transactions for the purpose of making payments or receiving payments from foreign clients. Any income or gains from such transactions are subject to taxation under the Income Tax Act. Overall, it is important for individuals, businesses, and even organizations to understand the tax implications under FEMA and comply with the guidelines set by the RBI and the Income Tax Department to avoid any legal or financial complications. Moving on to the next part of the video, we have the concept of repatriation. Repatriating funds abroad as a non-resident Indian can be a complex process, but with the right guidance and understanding, it can be done smoothly. The first step is to choose a suitable bank authorized to deal in foreign exchange transactions. The bank will then require some documentation, including the NRI's passport, visa, and a declaration form. These declaration forms should contain details of the remittance, such as the purpose of the transfer and the amount that is being repatriated. It is essential to keep in mind that the RBI regulations limit the amount that can be remitted in a financial year. NRIs can remit up to $1 million per financial year from their non-resident ordinary or NRO accounts after the taxes are paid, while remittances from the non-resident external or NRE accounts are tax-free. Non-resident Indians or NRIs often repatriate funds abroad for various reasons, including investment opportunities, family obligations, personal expenses. One common example of NRIs repatriating funds abroad is through the sale of property or assets in India. When an NRI sells their property in India, they are permitted to repatriate up to $1 million per financial year, subject to certain conditions and documentation requirements. Another example is through the use of non-resident external or NRE accounts. NRIs can deposit their foreign income into NRE accounts, which are denominated in Indian rupees and are freely repatriable. These accounts can be used for various purposes, including investments in India, expenses abroad, or as a means of saving for future use. Finally, NRIs may be able to choose to repatriate funds abroad through the use of FCNR accounts. These accounts allow NRIs to deposit their foreign currency earnings into an account that is held in a foreign currency, such as US dollars, and is freely repatriable. The FCNR accounts can be used for various purposes, including investments in India, expenses abroad, or as a means of saving in a foreign currency. Overall, there are various ways in which NRIs can repatriate funds abroad, and the method chosen will depend on the individual's specific circumstances and needs. Repatriating funds from abroad to India can be a daunting task, especially if you're not familiar with the process. However, with the right knowledge and steps, it can be done smoothly. So here is a step-by-step guide to repatriating funds from abroad to India. Number 1. Determine the purpose of your repatriation. Before you start the process, determine that why do you want to repatriate the funds. It could be for investment purposes, education, or even for personal use. Number 2. Understand the regulations. The Reserve Bank of India regulates all foreign exchange transactions in India. Therefore, it becomes essential to understand the rules and regulations governing the fund repatriation. You can check the RBI website for more information. Number 3. Gather the required documents. You will need to provide certain documents such as your PAN card, bank statements, and tax returns. Make sure you have all the necessary documents ready before you start the process. Number 4. Contact your bank. Contact your bank and inform them of your intention to repatriate the funds. They will guide you through the process and provide you with the necessary forms. Number 5. Fill out the said forms. Fill out the required forms and submit them to your bank, and make sure you have all the necessary information and documents to avoid any further delays. Number 6. Wait for approval. The bank will review your application and approve it if everything is in order. The process can take up to few weeks, so be patient. Number 7. Receive your funds. Once your application is approved, the funds will be transferred to your Indian bank account. Repatriating funds from abroad to India can be a smooth process if you follow the right steps. Make sure you understand the regulations, have all the necessary documents, and work with your bank throughout the whole process. Furthermore, repatriation with respect to property sale proceeds. So there are three scenarios when it comes to selling a property in India. When the property was acquired using Indian income, when the seller was a resident, when the property was bought using foreign currency after the seller became a non-resident, or the property is inherited from the seller's parents. We'll understand all these three scenarios. Number one, if the property was procured using foreign currency, then the repatriation of money is limited to the amount invested in the property. For example, if your property was acquired for INR 1 crore and sold for INR 2 crore, then the maximum amount of money that can be repatriated is 1 crore. This is a simple rule that applies to all NRIs selling property bought using foreign currency. Moving on, if the seller was a resident and used Indian income to buy the property, there are no limitations on repatriating the amount of money. However, we must understand if the seller has permanently shifted to a foreign country, then there is a limit of $1 million per year on the repatriation of money. This limit does not apply to the seller if he is still a resident of India. Furthermore, there are no limitations on repatriating the amount of money if the seller inherits the property from their parents. However, the seller is still subject to a limit of $1 million per year on the repatriation of the money. So in conclusion, we can say that the Foreign Exchange Management Act of FEMA is an important piece of legislation in India that regulates foreign exchange transactions and helps maintain the stability of the country's economy. The Act is designed to prevent the misuse of foreign exchange and to ensure that all transactions are conducted in a transparent and legal manner. It also provides guidelines for the management of foreign exchange reserves and regulates cross-border investments. Under the Act, individuals and businesses are required to adhere to certain rules and regulations when dealing with foreign exchange, including the requirement to obtain permission from the Reserve Bank of India for certain transactions. The Act also provides for penalties and fines for violations, which helps to deter illegal activities. Overall, the Foreign Exchange Management Act plays a crucial role in promoting international trade and investment while ensuring the stability of India's economy. It is important that individuals and businesses comply with the regulations and guidelines set forth by the Act to ensure that the foreign exchange transactions are conducted in a legal and transparent manner. Hope you found this video informative. In case you have any questions, you can write to us at query@nrilegalservices.com, and don't forget to like, share and subscribe for more informative videos. Thank you.